Thank you. Yes, Mr. Granville.
Good morning, Your Lordships. My name is Mr. Granville. I appear on behalf of the appellant, Mr. Kush. I'm joined by Mr. Alison Howes, who appears for Mr. Williams, Mr. Wood, who appears for Mr. Willis, and Ms. Kyan, who appears for the appellant, Mr. Tesan. Across from myself is Mr. Atkinson, King's Counsel, who represents the respondent, being the Crown.
Yes, well, can we start by thanking you all for the very helpful generic skeletons and submissions that you have all provided and which we have read. And can we also indicate at the outset that we have had and taken the opportunity to watch the video footage in each individual case.
Thank you, my lady. If I can start by addressing the court on the overarching principles on behalf of the appellants. This is the third item in the judge's bundle, the appellant's skeleton argument.
Yes.
I will briefly go through a few points in this. Of course, the court has indicated they have read it all already.
That's not intended to curtail anything you want to say, obviously, Mr. Granville. But on the generic principles, it occurs to us there may not be an enormous difference between you and Mr. Atkinson on the face of it.
Indeed, my lady, that's correct. And, of course, the second half of that application is to do with the pre-sentence reports, which is going to be far more of an individual matter, which I'm sure the individual appellants will deal with in turn.
Of course.
And as the court already indicated, a lot of it is agreed, and the applicants here do not disagree with the application of Blackshaw in principle. However, the appellant's main argument with this is that there should still be some form of distinction, even with the application of Blackshaw and with the overarching guidance that has come from that. There are still individual cases where mitigation should still be properly considered by the sentencing court and should outweigh what is a fine balancing act between, of course, a deterrent sentence and of course, the best punishment for that offender. And the appellants jointly submit that sometimes that will have to outweigh the deterrent sentence and lean towards the benefit of the defendant. The appellants will ask the court to, of course, look at what each appellant has actually done in light of the overall events. Of course,
I mean, nobody's suggesting that individual actions are irrelevant. It's just that they have to be seen in the wider picture, which also has to be taken into account.
Yes, of course, and it's also understood that the individual actions taking part within the greater context of the riot is understood to be an aggravating factor. However, the appellants jointly are submitting that there is significant mitigation for each appellant and significant circumstances that should be considered, so that it's not necessarily a blanket approach to the what the appellants submit are harsh sentences that have been imposed or manifestly excessive sentences.
I don't think anybody is suggesting there should ever be a blanket approach. Every case has to turn on its own facts.
And that is one of the basis of the appellant's submissions here, is that the mitigation may not have been properly considered, or the pre-sentence report not properly considered. Each appellant, of course, has their own position on this, and as I mentioned earlier, will be highlighted in greater detail when each appellant addresses the court, especially with regards to pre-sentence reports. I know for Mr. Kush, there is a separate argument with regards to how much consideration the court gave to the pre-sentence report. I'm aware that one of my learned friends had an issue where a pre-sentence report was not ordered at all. So no, not a blanket approach, but that the sentencing court should have due consideration and create a distinction between the rioting as a whole and their individual actions. Moving through the appellant bundle, if I can take the court to between paragraph 7 and paragraphs 12, it's essentially reiterating my first point that highlights the position in Blackshaw. They must be punished accordingly, but they, however, also designed to deter others from similar criminal activity. There is a difficult balancing act for the court whenever sentencing these offenders has to consider. We submit that it should be weighed more in favour of being an appropriate punishment for the offender rather than being a deterrent, which is why these appeals are here before the court today. And that, of course, links to paragraph 12 in our joint skeleton that, as I mentioned, all factors need to and submit should be considered before sentencing happens. And whether that is mitigation that needs to be considered, whether that's the recommendations in the pre-sentence report that should be considered, or a pre-sentence report at all. The court will, of course, be aware that suspended sentences can indeed be deterrents, as well as periods of immediate custody. I'm not going to elaborate much further on that, but the idea that it has to be a long term of immediate custody as the only deterrent available to offenders or potential offenders watching on, we submit is incorrect. And that suspended sentences hanging over a defendant's head, while still, of course, subject to other severe forms of punitive punishment, such as unpaid work, can act as a deterrent, but they can also act as rehabilitation for the offenders. Rehabilitation activity requirement days, mental health treatment programs, all of these are a rehabilitation which is also part of the sentencing exercise. It's not just to punish, but to help rehabilitate offenders, especially young offenders. I can speak for my appellant being 20 years old, within that 18 to 25-year-old bracket. Of course, the court may have a different view if they are older or more mature. However, I still suggest that rehabilitation is a very important part of sentencing considerations. The court, as well, of course, will be aware that public policy is a separate matter to the powers of the judiciary, and it is understood the events in the summer were events which affected the whole country. However, we still submit that the judiciary play an independent role in sentencing these offenders, and play an independent part separate from the legislative when deciding what is a deterrent, what the correct sentences should be, and how best to deal with these defendants. Again, it's a balancing act. It's a balancing act which I've highlighted.
Forgive me. What's the point you make about the judges being separate from the legislature, which we obviously are, but what point do you found on that that's relevant to the applications today and to sentencing generally?
This really links to paragraph 18 in the appellant's bundle, that even with the national events that are happening, the media coverage of it, and the significant and strong public opinion that can follow from what was happening, there is still a due process that needs to be followed. And this due process links right back to what I've been saying previously, that yes, there has to be a deterrent, but there also has to be rehabilitation and a suitable punishment for that individual offender. There is still a due process where reports need to be prepared, or reports should be considered if they have been prepared, and that mitigation should be properly considered for each individual being sentenced. It is not a point I'm pushing too hard, but it is a point I make that, of course, these are sensitive matters, and they are also matters of national significance. And I push for the court, when considering these appeals, to bear in mind that they should be dealt with individually, and dealt with as though the courts were dealing with any sentence, rather than considering any other public influence. Not that I'm suggesting the court will do that. That really summarises the appellant's overarching response, the court, of course, will have read the several pages that have been jointly submitted. Unless I can assist any further with regards to that part.
No, I think that is very clear and very helpful. And the gravamen, really, from each of your perspectives, is the individual facts of your individual cases. Subject to anything Mr. Atkinson has to say, I think it seems to us sensible for you each to make your submissions one by one, and then for Mr. Atkinson, if that's convenient, to respond in one sweep, both on a generic level and then by reference to each individual case.
Yes, ma'am.
Thank you very much. So, Mr. Granville, your client, Mr. Ozzy Kush, aged 20.
Yes, my lady. I'll just get to the correct section. Hopefully the court has a copy of the perfected grounds,
yes.
the amended grounds,
yes.
for Mr. Ozzy Kush.
So, Mr. Kush, then aged 20, involved in an incident at Whitehall on the 31st of July, 2024.
That's correct.
Charged and pleaded guilty to a single offence of assault by beating of an emergency worker, contrary to Section 1 of the Assaults on Emergency Workers Offences Act 2018, sentenced to 46 weeks detention in a young offender institution.
That's correct, my lady. Yes. That was part of what was called the Downing Street riots. He was sentenced to 69 weeks, had it gone to trial, and after credit, went to 49 weeks. 46. 46 weeks. There are two grounds to this appeal. Firstly, that the sentence was manifestly excessive, and secondly, that matters should have been considered that were not, namely the conclusion of the pre-sentence report. Starting with ground one, the court will see this starting at paragraph 12 on page 3 of that bundle. It's accepted by the appellant that the riots were an aggravating factor and that his offence, assaulting an emergency worker, within that context, counts as an aggravating factor within this. Ultimately, submit this, however, is still manifestly excessive. At the sentencing hearing, it was agreed by the bar that this was categorised as A3. The sentencing judge categorised it as A2, and that's what it was sentenced upon. Category A is accepted, the use of a shod foot to the officer's hand. It's the level of harm that was disagreed upon between ultimately the bar and the sentencing judge. You will have seen from the statements and you'll have seen from the reports that the officer suffered a momentary pain.
Yeah, it hurt and his hand went numb, but I mean the three grades of injury are in the context of this being common assault. So I mean if the officer had a cut hand, it could be ABH, it would be a bit of a stretch to be a section 20, but it could be a more serious offence. So we have to bear in mind that even the top category is still the top category of common assault. So perhaps put bluntly, it doesn't take a great deal to get to the middle category, and maybe isn't a smarting hand that goes numb, isn't that? And P.C. Mont also wrote, I think, about really how upset might not be the right word, but how taken aback he was to be faced with this sort of violence when he was trying to protect the community. So isn't the judge got enough there to get from the bottom one to the middle one?
Yes, my lord, I hear what's being said, and of course within the context of the riots it is of course exaggerated. It was only that it was agreed at the bar at the time of being category 3, and there was not honestly much more thought to it than that. It is not a point I'm going to push because the grounds being manifestly excessive still apply to it if it stays within A2.
Okay.
It was a point I wanted to raise with regards to sentencing guidelines. The court will of course be aware that category A2 gives a range of a low-level community order to 16 weeks with a starting point of a medium-level community order, with the defendant entering a plea at the first opportunity. Even at the top level of this category of 16 weeks custody, the defendant was, before credit, sentenced to 69 weeks custody. Again, within that submission, we submit that simply as manifestly excessive, even with the balancing act the court has to consider, which I spoke about previously.
And even taking into account the maximum sentences for the different offences?
Yes, my lady.
I mean, to take up my lady's point with great respect, that the maximum sentence for the offence of which this applicant was convicted is
2 years.
Well, yeah, but it's 4 times the maximum sentence for the offence which the table is drafted to consider.
Yes, my
I'm
lord.
not suggesting you have to multiply the table by 4, but isn't Parliament saying in the right case one might need to?
Our submission is that's not the case with this applicant. There is significant mitigation and history that uplifting even the top end of the category by 4 times is too much, quite simply. And I will come on to more significant mitigation in a moment. I did put some within the grounds to try and give the court an idea of who this individual is, but I will expand on that. I'm not going to expand any further on the sentencing guidelines. The court will be well aware of those, of course.
Yes. What is it that you say the sentencing judge left out of consideration?
That's the second grounds of appeal, my lady.
I mean, is there more you want to say on the first one?
Sorry, my lady.
Is there more that you would wish to say on the first ground of appeal?
Only to expand on the mitigation.
Right, well, do expand on the mitigation then.
The court will see defence mitigation starting at paragraph 17.
Yep.
There is one previous conviction which is yet to be sentenced. As you noted, this was for criminal damage to a door at the family home before he was kicked out of that house. The reason he was in London that day was to visit Harry Potter film locations. It was something that made him positive. It was a positive thing for him. It was something that made him happy. And he found himself stuck in a situation where he didn't want to be. He went down the wrong road, and he was caught between the police and the EDR march. The sentencing judge has acknowledged that this applicant is not part of any right-wing extremist groups or holds no prejudicial values in that sense to be part of that group. This was the group outside Downing Street. And he was caught essentially between the two. Due to his many adverse child experiences, one response of his is to resort to violence. He reacted the way he did because of previous abuse from his father when he was younger. And we know individuals react differently when intimidated. And
so where is the evidence to support that submission?
There isn't any further evidence.
Wasn't in the probation officer's oral report? Was there? There was no link made by any body appearing in front of the sentencing judge that I have seen, I don't think.
In the pre-sentence report, the court will note the many mitigating factors and especially the mental health difficulties that the report writer considers the defendant to suffer from. He has a limited education, but he does have his CSCS card. Unfortunately, he'd been out of work due to a workplace injury, and his finances were disappearing, which was leaving him homeless. Ultimately, it was a stupid and immature decision by the applicant, and poor decision-making skills which he could benefit from support with. I will move on to ground 2 with regards to the matters that were not taken into account. This refers to the pre-sentence report that your ladyship raised a moment ago.
Yes.
Upon committal to the Crown Court, the District Judge at Reading Magistrates Court didn't order a pre-sentence report. Then, going to visit the defendant in the cells at Inner London Crown, probation turn up and say we've been asked to do a stand-down report.
Yes.
So that was, you'd been ordered by the court, I can only assume. The hearing took place and the probation officer delivered the stand-down report to the court. When getting to the recommendations, the sentencing judge cut him off and said, essentially to the words of, I don't need to hear that. It's our submission, or my submission, that if a report has been ordered by the court, and a full and all options pre-sentence report has been ordered, then the recommendations of the probation services should be heard by the court. If the judge decides to sentence, the judge's sentencing powers are up to them. They do not have to, of course, follow the recommendations of the pre-sentence report, but I submit that they should have at least been heard by the sentencing judge. The difficulty we have here is that the report was then later uploaded to DCS. However, there's no way of knowing if the sentencing judge paid any consideration to what the recommendations were. And the court will see in the pre-sentence report, which is at number 17 of your bundle, the extensive mental health concerns that the report writer had for the appellant, as well as, of course, his genuinely ignorant to the reasoning behind the riots. He needs help securing employment and accommodation. They had suggested a number of programmes which the appellant could have taken part in if sentenced in the community. The report writer states their personality disorders are prevalent, emotional instability and childhood ACEs.
Sorry, just the point about not paying any heed to the probation officer. The judge, I'm looking at his sentencing comments at Y4, if that helps. In passing sentence, the judge did say he's had a report from a probation officer, you've been homeless, you're unemployed, you've worked in the past, you've problems with alcohol, you don't have problems with alcohol or drugs, poor mental health, possible personality disorder, expresses a view about his level of remorse, and then a risk of reoffending, etc. So, I mean, in terms of what the probation officer can tell the judge about the applicant, that all seems to be in there, doesn't it?
Yes, my lord. The submission is based around the recommendation that the probation services provided, and that the court did not have any consideration to it, but didn't even listen to it. And as advocates, we do not know if it was considered because the report was only uploaded later on. So we can't even be sure that when the learned judge retired to consider sentence that the report was read. We don't know. There's no mention of that. And this may be an empty point ultimately. However, it is my submission that if the court has ordered an all options report, the court should consider all the options that are recommended.
Thank you. I understand how you put it. Thank you.
Of course, in the context of the riots, there was a recommendation of a 24-month community order with 30 rehabilitation activity requirement days and an unpaid work requirement. And I'm sure with the report writer looking at the sentencing guidelines will have considered what was available when looking in the different categories. This is, of course, a sentence that very much could have been available within category A2. It's not one that I'm suggesting now should have been. However, I am saying that this is something that should have been considered when looking at either the length of the sentence or whether or not it should have been suspended in the first place. But all of this, we submit, were not considered by the judge, the learned judge, when sentencing, because the report writer was cut off partway through delivering his report.
Sorry, you say halfway through. I think I'm just making a note. Or we don't have a transcript of this, but you're saying that he was stopped at the stage of making a recommendation.
Yes, my lady, it's not in the transcript, unfortunately, and it's probably, it would be my fault for not requesting that part of the transcript. It was a stand-down oral report. The probation officer did speak at length about the appellant, which was heard, and when he got to the point of suggesting, he said my recommendations for sentence.
Understood. The judge said you didn't need to hear.
Essentially, my lady, yes. In conclusion, he submitted that the sentence was manifestly excessive in both its length and the uplift when considering the aggravating factors. The learned judge did not give sufficient weight to the appellant's lengthy mitigation, and that the learned judge ought to have considered the recommendations in the pre-sentence report ordered by the court. Even if the learned judge was not going to suspend the sentence, it would have turned his mind to length of sentence, another factor that should have been considered when considering the uplift for this matter. The sentence is, in my submission, manifestly excessive, and it ultimately leaves insufficient headroom for more serious offending within the sentencing guidelines for this offence. Unless I can assist the court any further.
No, thank you very much indeed, Mr. Granville. Thank you. Miss Alison Howells, you're next. Paul Williams, then aged 45 years, Sunderland riot, 2nd of August 2024, pleaded guilty at the first appearance to a single offence of violent disorder contrary to section 2(1) of the Public Order Act 1986, sentenced to 26 months imprisonment.
My lady, I'm very grateful for that summary. It, of course, saves me revisiting the same facts. I, of course, appear without leave from the single judge, but do seek leave to appeal against sentence on behalf of Mr. Williams, arguing effectively two grounds. My lady, my lord, there have been a number of documents uploaded to the digital case system and, of course, added to a bundle in respect of Mr. Williams. May I check that this court has had the opportunity to consider those documents in advance?
Yes, indeed.
I'm very grateful. The perfected grounds, of course, can be found at item number 5 on the digital case system.
Thank you.
For the Court of Appeals section. My lady, my lord, the arguments essentially, ground 1 is advanced to suggest that there was an element of double counting which existed in ultimately calculating the total sentence length. If your ladyship and your lordships are with me that that is an arguable ground, then of course I can move to consider ground 2, which is effectively submitting that if the sentence could have been reduced to 24 months, as I respectfully submit, there could have then been an argument for suspending that same sentence. Effectively, this is a mercy plea, not for Mr. Williams, but for his teenage son. It is apparent from the documents and from the perfected grounds that it is his teenage son who is most impacted by his father's term of immediate imprisonment. And as I say, it is a mercy plea for his son rather than for Mr. Williams.
The son is 14, and you've seen the updated family report, have you as well?
I have, yes, my lady. I was most grateful to the parties who participated in the preparation of that. It was perhaps my respectful view, and it may have been the court's view, although it may not have been, that that report doesn't effectively take us much further forward because, of course, the family is closed now to social services, and the relevant party within social services reported as such and said that it was anticipated that the teenage son would have struggled, but it was equally anticipated that the family would look after him. It is my respectful submission that the report from the Children and Family Courts Advisory Service, which was served in advance of sentence, is perhaps the more illuminating document as to the teenage son's state of mind in advance of sentence, I must concede, but without an actual report. I have taken instructions. If it would assist this court to deal with that point now, I can of course do so in terms of how Mr. Williams' son is coping, or I could leave that until ground 2 effectively and deal with all those matters.
Well, deal with grounds 1 and 2 together. They don't split them up, just go through both of them.
I'm very grateful.
Thank you.
There is no argument taken with the categorisation of this offence. All parties were in agreement at the date of sentence that this was a culpability B and harm 1 offence. I certainly make no argument today that that should be changed in any way. The sole argument relates to the perceived double counting of factors which were taken into account when categorising culpability as culpability B. As set out in the perfected grounds, those same factors were then used to further aggravate the starting point, when in my very respectful submission, they had already been used to place the offending within culpability B.
If we look at culpability B, and there's 4 possible qualities that would get us into culpability B, if 3 of them are there, then to an extent, are they exhausted by the categorisation, or is the judge entitled to say, well, I've got 3 routes to culpability B, so the fact that the 3 are present means 1 or 2 of them can feature to some extent as aggravation. Is that right, or is that something he can't do?
My lord, it strikes me that the sentencing guidelines and the authorities are somewhat at odds with each other. The authorities, as set out in the overarching principles, seem to make it clear that individual action should not be regarded with any great detail. It can be regarded, but sentencing judges should look at the bigger picture. I concede that is entirely correct. Sentencing judges, in my very respectful submission, would be then wrong to take the view that I have perhaps ticked 2 out of 3, and that leaves a balance of 1 for me to use as an aggravating feature. Because on the sentencing guidelines, it does make clear, my lord, that when looking at aggravating features, there is a note written in bold on the website of those sentencing guidelines at the top of aggravating features, stating care should be taken not to double count aggravating factors which were relevant to the culpability assessment, particularly in cases where culpability is assessed as high. Plainly, this is not a high culpability case, it is a medium culpability case. But when then turning to look at the factors which do increase seriousness, previous convictions, I of course concede, is relevant and should have been used as it was as an aggravating feature. The offence was not committed whilst on bail, and the 3rd and final statutory feature did not apply. But when perhaps we look at the other aggravating features, active and persistent participant, offender through missiles, objects, use of significant physical violence, all of those features perhaps could be aggravating features were they not already used to put this appellant within culpability B, where those features of the mass disorder had already been used.
I wonder, Ms. Harrison-Howes, whether there are really 2 separate points here. The first is a general point about guidelines. A single feature within a particular category will often, indeed generally, be sufficient to put the case into that category. If, in fact, more than one category feature is present, as a matter of general principle, the judge is entitled, is he not, to adjust the starting point upwards to reflect the fact you're not just in this category for 1 reason, you're in it for 3 reasons. But then separately from that, in relation to this particular guideline, when we look at the culpability B factors, they're directed, aren't they, to the nature of the overall incident in which the offender participated. When we come to the non-exhaustive list of aggravating features, they can relate to the role played by the individual.
Yes.
And to put it simply, in Mr. Williams' case, he would have been in category B for all the same reasons, even if, for example, he hadn't thrown any missile. And if you imagine 2 men side by side in the disorder doing much the same as each other, but one of them does throw a missile, isn't he in a worse position than the one who doesn't?
My lord, it's absolutely an astute point, and it's where the confusion perhaps arises in the sentencing guidelines. Because, of course, the case law makes clear that those 2 men should not be distinguished. We are looking at the overall picture. And if you stand side by side with someone hurling missiles, to follow the case law would seem to suggest that you are equally as culpable and should face an equally severe sentence. But the element of confusion, and perhaps the ground on which this application is based, is because the guidelines then do go on to stipulate, when looking at those statutory aggravating features, which of course in plain English relate to the actions of the individual, the government, when drafting, has stated there should be no double counting for factors which were already used to categorise culpability.
Not the government.
Forgive
the
me, my
Sentencing
lord.
Council.
Yes.
We're fiercely independent.
Back to
Oh, certainly, yes, no.
independence, Mr. Granville.
No suggestion otherwise, my lord. But certainly there is confusion, is my respectful submission.
Well, thank you, and I understand the point, of course, but I don't think the case law goes as far, does it, as to say that absolutely everybody must be treated exactly the same if they can all be said to be in some way part of the same disorder. And indeed, quite a lot of the mitigation for several of these applicants is, well, all right, I was in it, but I really didn't do very much at all.
There can be no such argument for Mr. Williams.
No, indeed.
He played and conceded at the earliest opportunity. His role was active and persistent and wholly disgraceful. He has conceded that immediately, so there is certainly no such argument on behalf of Mr. Williams that he effectively played a lesser role and so should face a lesser sentence. The sole argument in relation to the starting point for sentence and the eventual sentence that he received is that those factors have to be present in order to be in culpability B with the factors that have been referred to and that were relied upon by the learned sentencing judge. In order to fall within that category, there must be persons committing those acts. It is quite right that the appellant was committing those acts. But then, having been placed in that category, and with that caveat in the sentencing guidelines about double counting, I take, of course, your lordship's point entirely that culpability speaks as to the general incident, whereas the aggravating features speak to the individual. But because of this lack of clarity as to the double counting, there exists, in my very respectful submission, arguable ground to say that the actions of Mr. Williams were already accounted for in placing him into culpability B, and then were used again against him to inflate that starting point.
Good. I think then that's very clear. We've got that point. So where do you think that should have taken the judge in terms of sentence?
In terms of the applicable aggravating features, my lady, it was my submission that only antecedent history and intoxication should have been taken into consideration. When balancing that out with the mitigating features, principally, of course, his entitlement to full credit for an immediate unequivocal plea and his unique family circumstances, there would have been a balancing exercise carried out, which would have allowed the sentencing judge to remain at the starting point of 3 years, afford full credit of 1/3, and result in a final sentence of 2 years, 24 months, and then consideration could have been given to suspension of the same.
Yes.
Does that assist, my lady, in respect of that point?
Yes. Is there anything more that you would like to say about ground 2 and suspension?
In respect of suspension, my lady, I've set out in the perfected grounds the unique family situation. I have taken updated instructions this morning from Mr. Williams, who tells me he is in communication with both children very regularly. Understandably, they are struggling to come to terms with their father's imprisonment, a situation Mr. Williams is quick to recognise he has created. In terms of his son, most principally, I say this not to minimise the harm that is, of course, caused to his daughter, but it is his son who has lost his permanent home. When Mr. Williams is eventually released from custody, he will need to join the queue, effectively, for emergency accommodation because he has lost his accommodation by virtue of his imprisonment. But effectively, my lady, I would argue that the sooner that Mr. Williams joins that queue, the sooner he may be able to secure suitable premises to begin once again housing him and his son and resuming those weekly overnight stays with his daughter. The updated report from the probation service has been enormously helpful. It's ultimately my submission that if this court is minded to consider suspension, it has been deemed that the risk Mr. Williams poses is suitably low so as to be managed in the community. A term of suspended imprisonment with conditions attached, 35 rehabilitation activity requirement days, and a 120-day alcohol abstinence monitoring requirement could be attached to him to address those underlying criminogenic needs which will continue to persist until they are properly addressed. In terms of any floodgates argument that may concern the court or the public, lady and my lords, this appellant is in very unique circumstances in my respectful submission. it is fairly unusual to represent a male appellant who has custody effectively of his child. It is not a situation, certainly, that I have encountered with any regularity, and it would, in my respectful submission, quash any suggestion that if he were to receive a suspended sentence on such grounds, then effectively any defendant or appellant with caring responsibilities could also receive the same. It is not something that I submit need trouble the public nor the court, because it is such a unique set of circumstances that he finds himself in. May I be of any further assistance to this court?
No, you've been very helpful as well, Miss Alison Howells. Thank you very, very much.
Thank you very
indeed.
much.
Thank you. Yes, Mr. Wood, Dylan Willis, Middlesbrough riot, 2 days later, 4th of August 2024, 18 years old at the time, pleaded guilty, single offence, violent disorder, again contrary to Section 2.1 of the Public Order Act 1986, sentenced to 14 months detention in a young offender institution.
That's right, my lady. My lady, the thrust of my submission in relation to Dylan Willis is that he can be treated by the court as an exceptional case, a truly exceptional case, but additionally that the starting point adopted by the judge when taking into account his exceptional circumstances was too high. The starting point that the judge adopted in his case was 39 months.
You don't mean starting point, you mean the term, not starting point within the meaning of the guideline. You mean the term taken before applying credit for guilty plea, do you?
That's right, my lady, yes. So that term the judge started at before making reductions, not only for credit for guilty plea, but also before making some reductions for personal mitigation, was 39 months. That was the way that the sentence was expressed by the learned judge when the sentence was passed. I'll find, Your Ladyship, the reference within the transcript in a moment. Allow me a moment, please.
Yes, so that's page 4B of the sentencing remarks.
Yes.
So 39 months before deduction, credit for mitigation, and then credit.
And then credit.
Yeah.
And my respectful submission, my lady, is that 39 months as the point that the judge considered before making those reductions was too high when considering the conduct of this particular appellant, notwithstanding, my lady.
What was wrong with the 39 months? Starting point under the guideline was 3 years. You
Yes.
don't complain about categorisation.
No.
And then because of the large scale, the extent of the disorder,
Yes.
an additional 3 months. What's wrong with that?
Well, my lady, whilst I concede that the Middlesbrough incident on the 4th of August was widespread and had all the hallmarks of the particular aggravating features that have been raised quite properly, I respectfully submit this comes back to the point that's been mooted before you already in relation to individual actions versus widespread disorder. And in fact, the 39 months, the individual actions of this case were, if one takes the individual actions in a vacuum of someone throwing a brick at a window, which is what this appellant's done. He threw a brick at a window, the window didn't smash, and he made an effort to pick the same brick up and throw it again until the window did smash in an environment where it's understood that the commercial premises were empty, and I think in fact it was a Chinese takeaway, my lady, where he was throwing the brick. If you
I'm sorry to interrupt you, Mr. Wood, but I just wonder whether there might be a confusion of 2 points here. So the judge took the 3-year starting point, and he increased that only on this express basis that it's such a large-scale disorder set against the background of other disorders around the country.
Yes.
So he's not increasing the starting point to reflect any individual actions. he's saying that this particular incident is significantly worse than other violent disorder offences in the same category because of the context of it happening all around the country.
Yes.
And to echo my lady's question, what's wrong with that as a matter of principle?
Well, I don't submit that there is anything wrong with it as a matter of principle, my lord, but
You'd be hard-pressed to say adding 3 months to 3 years is too big a leap.
Well, my lord, my submission is that that whilst we don't treat the defendant, pardon me, the appellant's individual actions in a vacuum, it's being treated in the context of the wider disorder. His actions in particular didn't have, when I'm talking about his individual actions, didn't have any of the aggravating features that many others had. For example, he threw a brick at a window. He didn't throw a brick towards other individuals. He didn't throw a brick towards the police. He wasn't wearing a face covering. He wasn't using any racist or abusive language. His offending was limited in duration and scope. And for those reasons, my submission is that whilst I concede that the judge has only increased the sentence as what I was referring to, my lady, as his starting point, 39 months, he'd only increased from the 3 years to 39 months to take into account the wider disorder. My respectful submission is that the reduction should have taken place from that 3-year starting point before reduction of his personal circumstances, and then reduction for mitigation. So my point is the 3-year starting point that was increased to 39 months should have in fact been less than 3 years because his offending was so limited in scope and duration. I accept that might not be my best point, my lord, but that I do make that point on behalf of this appellant. In relation to his personal circumstances...
Do you say, forgive me interrupting, but I think I'm being helpful. Do you say that, and he's 18, that you cite what this court said on a number of occasions, that age is not a cliff edge, so if you have an immature 18-year-old, you might need to think of them as if they were under 18, and thus in law, quote, a child, unquote. Do you say we're in that territory with your applicant?
Pardon me?
You say we're in that territory. The court should approach as if he was under 18 because it's not just about chronological age, it's about development as well.
Yeah, yes, my lord, and I suppose my point is that the first point was that I'm submitting that the judge has adopted a starting point that was too high, and that would have been for perhaps an individual who could well have been 25 without any difficulties, much older than this appellant. But in addition to that, because of this appellant's age, and this is the focus of my personal mitigation, because of his age, the cliff edge points that I've raised, and I've directed the court to 2 authorities which I know have been presented within the bundle. He's an 18-year-old. He was 18 at the time of the offence. He was 18 when he was sentenced, and he's still 18 now, my lady. And his position, in my respectful submission, is it's not just the cliff edge point, although I think the cliff edge point is extremely relevant to him, is that, my lady, the court will have seen the documentation about the particular vulnerabilities of,
yes.
Of this individual.
There was autism, ADHD, low IQ, low maturity linked to the offending.
Yes. So, and this isn't a case where he has a learning difficulty, for example. This is a diagnosed learning disability. He has an adult social worker and cannot live independently. So the thrust of my submission on, still to some extent with one eye on the cliff edge point, is that many youths who have demonstrated conduct far worse than throwing a brick at a shop window in the context of wider violence. So, for example, youths who had face coverings, racial abuse, throwing missiles at officers, have been dealt with by the youth courts up and down the country, have received sentences that did not mean immediate custody. And in this particular appellant's case, my lady, my submission is that whilst his chronological age is 18, the material that has been prepared for these proceedings suggests that his developmental age may well be significantly less than 18, and it may well be we might have 15, 16 and 17-year-olds far more mature and sophisticated than Mr. Willis. And so my submission is that the court should have given greater weight to that particular submission. There is a post-sentence report
Yes.
or a progress update, my lady, in this case, which I'd submit is helpful and actually makes the point perhaps better than I've just made it. On page 2 of that report.
Is this the 8th of October or the 25th of October one?
The 25th of October, my lady.
Thank you.
At the top of page 2 of that report,
Yes.
the third line down, it says, Mr. Willis continues to struggle to recognise the impact of his behaviours on the wider public. So whilst on the one hand the court is, of course, going to take into account the impact on the wider public and take into account the wider perspective of this type of offending, the reality is in my submission and is that this particular appellant has a very limited appreciation for the wider public perspective and the wider public impact. And that, in my submission, feeds into the Sentencing Council guidelines on sentencing defendants with mental disorders, neurological impairments, when my lady, the court is considering culpability. Did this particular appellant's difficulties impact on his ability to make rational choices, exercise appropriate judgment, understand the nature of consequences of his actions? Well, my respectful submission is that this report highlights that even now he doesn't fully understand the nature and consequences of his actions, and what it goes on to say is that this could well be related to his autistic spectrum diagnosis. And so, my lady, in his case, we have his age as one significant factor, but also his impairment as a further significant factor, and I respectfully submit it's the combination of those two factors that make this sentence manifestly excessive. It's also important, I think, finally, in mitigation for Mr. Willis, that there were additional factors present that fall within the sentencing guideline for violent disorder under the factors reducing seriousness or reflecting personal mitigation. He was of no previous convictions. The guideline itself does take into account, it uses the phrase minor role, and my submission is he did play a minor role within this public disorder in Middlesbrough. Remorse is a factor that the court are entitled to take into account, and in his case, my lady, I think that there is a demonstration of remorse, even notwithstanding his difficulties in understanding. He saw the photographs on social media, the social media campaign for people to come forward who had been involved in the offending. He handed himself in, didn't wait to be arrested. He discussed handing himself in with his social worker. He felt it was the right thing to do. I would submit that does amount to remorse. I've covered age and lack of maturity. I've covered his learning disability. Also, my lady, the court will have read within the report about him his deprived background, difficult personal circumstances, I would submit that they are also important in his case.
Mr. Woods, just before you finish, can I just ask you this? You've made a number of points perfectly properly about the nature of his actions. We see from the CCTV footage it's a pretty determined attempt to keep throwing the brick until the window smashes. Do you have any instructions about why that window?
I don't, my lord. The only thing, the only instructions I do have is that the appellant tells me he got caught up in what was going on. He was remorseful for his actions, and he wanted to emphasise that this was not a racially motivated attack. In fact, there was no suggestion from the prosecution that this was commercial premises targeted because of their owners. And I ask that the court take that into account as well. Yeah. So in conclusion, my lady, the prosecution say, well, the judge has taken into account all of those things and reduced the sentence, and it's right, he has. My 2 points are this. The starting point was too high, from which the reduction was made, and if the court's not with me on that, the starting point was too high, then my submission is that a more substantial reduction should have been made, in particular relating to the cliff edge principle in turning 18, and additionally on top of that, his special educational needs and all that goes with that. I hope that outlines the position for Dylan Willis, my lady.
It certainly does. Thank you very much indeed, Mr. Wood. Any further questions? Thank you very much indeed. Yes, Ms. Kukin. So the next day, 5th of August 2024, Plymouth riots, Amindabad Temesgen, then aged 19, single offence of violent disorder, guilty pleas, sentenced to 14 months. It looks as if imprisonment rather than detention.
Yes.
We all agree it should have been detention.
Yes, my lady, no issue will be taken on that point.
No, thank you. Yes.
My lady, my intention was to make submissions, I suppose, in 3 categories. The first, distinction in terms of his culpability. Second, lack of information through a pre-sentence report. And finally, the balance that's taken in terms of suspension, in terms of his particular mitigation. I do wish to raise at the outset, my grounds are largely focused on this is a sentence that could and ought to have been suspended. Of course, we are now 2 months on from that sentencing exercise, and the court will be well aware that he is eligible for home detention curfew at the end of this month. In Mr. Temesgen's particular case, I do wish to flag that there is a particular difference between a sentence over 12 months and a sentence under 12 months. That is initially because of provisions on when a conviction becomes spent. It's particularly pertinent to Mr. Temesgen, given his, and he does have a place deferred for higher education. Of course, the conviction becomes spent 4 years later, should it be a sentence of over 12 months compared to under. The second is to do with his status to remain in this country. It's not something that was before the court at the earlier stage. There wasn't a pre-sentence report. Those inquiries hadn't been made. He came to this country age 11 from Sudan with the rest of his family. He has settled status. His family, and indeed his intention, was to apply for a passport this year. A sentence of over 12 months is, in his case, particularly different, because over 12 months requires a referral for it to be considered by the Home Office.
It's a matter of principle, though, isn't it our job, well, it's the judge's job at first instance to impose what he or she thinks is the proper sentence, and then it's our job to see if it's susceptible to appeal for the reasons we all know. And shouldn't we not leave it to Parliament to decide what the consequences are in terms of other matters such as immigration status? Is it really for us to be tweaking sentences or tweaking appeals with an eye on what Parliament's decided is the proper approach on matters such as passports and permission to remain?
My Lord, yes, although it's not simply the case that a sentence is a sliding scale of there is only a difference of a month between 12 months, 13 months, in the same way there would be 13 and 14 months. The same is considered by judges when considering whether a sentence comes into that category that should be suspended, it is proper for a judge to consider those outside factors of the implications of the number in terms of the years of custody when they reach the sentence that they then impose.
So that I'm clear, Ms Coykin, issues relating to the rehabilitation period and
Yes.
issues relating to any immigration status problems that might arise were not raised before the judge?
No, well, so the issues, no, they weren't, is the short answer.
Thank you.
In terms of disparity and culpability, it's paragraph 20 of my grounds asserting that he isn't member of a fascist group. He doesn't attend the riots with any purpose of having any racist intent. It's stated by sentencing judge his role was by no means as serious as others participating. And it was accepted by that sentencing judge that he was racially abused on his arrival at the riots. That played a part in what he then went on to do. The deterrence sought by this type of sentence is preventing unprovoked, unlawful mob violence. Circumstances applying to Mr. Temeskin are somewhat different. He arrives, he receives that racist abuse, bottles are thrown at him, and quite evidently from the footage, he improperly throws those bottles back. In terms of the case law, in Blackshaw, the riots that were taking place nationally at that point, the intention by all parties was very clear. It was effectively mass public disorder. These riots are somewhat different, and my submission is there can be a differentiation into what type of role parties were intending on playing when they attended, which, I suppose, mob they were part of. That is considered by the sentencing judge in this case in terms of his consideration as to the harm. In terms of the Plymouth riots, and they were considered in all cases of violent disorder, victim impact statements were taken and uploaded onto the digital case system of the impact the riots had had on the community. I refer specifically, and it's a statement by Mr. Muganzi, these statements in part are to do with the disorder that takes place in the town centre. However, they are also relating to the impact of the racist behaviour taking part in the city centre. Mr. Muganzi refers to concern about targeting of the Islamic community and effectively racial hatred. It's not something that Mr. Temeskin plays a part in or cause. I'm not sure it can be said that the harm by his behaviour leads to enhanced fear by those of ethnic minorities in Plymouth.
If he throws bottles at... I mean, there may be reservations about whether we should be punishing people for whether they're right-wing or left-wing rather than what they do when a riot started. Yes. But if he throws bottles at a right-wing group and then they go on to react by rioting and people get racially abused, he's not unattached to all this, is he?
There's no...
Isn't that the problem with throwing bottles at what's potentially a very violent situation?
And he's in no way unattached, and he's of course being sentenced in the context of a wider public disorder, and that's rightly so. It's not to say that he's unattached, but it is to say that there is a difference between what is, I suppose, considered to be a racist mob attack and a response by someone who is racially abused by that group, and the impact that those two actions have on the community and have on the wider harm. There is a consideration for Mr. Temeskin about quite how deterrent any sentence applying to him can be. His circumstances are, of course, highly unique. He doesn't have a preformed intention to take part in a violent disorder, doesn't intend on aligning himself with the most severe of rioters. Majority of those, and it's a similar point taken by my learned friends, will not have the background that he has in terms of being subject to the racist abuse he has been in his life. On to the second point regarding a pre-sentence report. It's of course not in the transcript. Mr. Temeskin's hearing had originally been listed for sentence the day prior to the sentence.
Can you speak up a little bit, please?
Yes, I will do, and I'll move the microphone.
Yes, thank you.
Mr. Temeskin's sentencing hearing was originally listed the day prior to the actual sentencing exercise. The prison didn't produce Mr. Temeskin, and therefore it was adjourned by one day. On that date, I asked for a pre-sentence report to be prepared for Mr. Temeskin, and that application was refused by the sentencing judge. he did give permission for probation, who were in court, to speak to Mr. Temeskin, but was very clear that he would not be ordering a report and it wouldn't benefit the court. Such a report was necessary for Mr. Temeskin in terms of providing the mitigation that is before the court today, because there is that newfound report from probation on the digital case system. The authorities are very clear: younger the offender, the more likely the court will be to benefit from having such...
What particular point from the pre-sentence report was missing from the judge's understanding?
I suppose two. So the first is that the judge considered that all points that could have been made were made by counsel on the day. The assessment that's made by probation is a calculated assessment of risk. That's not an assessment that can be made by counsel from a professional source.
Right. So the first thing he didn't have was an assessment of risk.
Assessment of risk.
And the second point?
The second point is that the author of the pre-sentence report speaks to Mr. Temeskin's family support worker, family social worker. That family social worker is able to provide more direct information about the role Mr. Temeskin plays in caring for his sister. And the report we now have is, of course, a consequence of him now being in custody. So, of course, it would have been different had it been prepared on the day. But what that social worker is able to say is he is very much needed at home and is able to say the impact that has happened to his family since he's been in custody.
Well, but a report on the day wouldn't have told you the impact of him being in custody months later. Forgive me to
Yes.
to focus you, if I may, on my lady's point. Is there a fact that you, I'm sure, very ably and carefully didn't set out in front of the judge, which probation report would have set out in front of the judge?
I think there is a distinction between counsel in court saying this is a defendant who's highly remorseful, he is able to operate in the community, and an experienced probation worker being able to say, in my experience, he is exercising a high level of remorse and he is someone we very much would be able to work with.
It's a question of weight, is it?
It's a question of weight.
The weight of the probation officer confirming what you were saying.
Yes, that's the point I referenced in terms of the comment of counsel is able to say all that can be said on this party's behalf. It isn't counsel simply saying it. It is the weight from a probation worker and their ability to access the frameworks in terms of assessing risk.
I mean, those are fair points, if I may say so, Ms. Coykin, but when we look at what the judge actually said at page 3F, he accepted immaturity, he accepted that the applicant and his whole family had been subjected to hate crime, he accepted that there was no need for any kind of rehabilitation, and he accepted, quote, heavy responsibilities to your family, and he accepted that the applicant was an asset to his own community, Sunday school teacher, and accepted he'd let others down. So is there anything you can point to and submit to us? Well, the judge didn't seem to accept this point, and he would have done if it had had the independent support of a probation report.
What the independent probation worker says is that Mr. Temeskin was undergoing significant strain in his life at that point due to him returning from Bournemouth to Plymouth to care for his sister. The suggestion is that causes him a significant turmoil which plays into his culpability and also his level of maturity.
Just take us to, if you would, the pre-appeal report. Significant strain due to returning to work or to look after the sister. Where do we see that, please? The bottom of the third page of the report.
Yes, my lady. In the category of relationships.
Yes, thank you.
I suppose the only other point that the learned judge was not able to consider in the absence of such a report is considerations in relation to thinking and behaviour. It was a mitigation that was available without that risk analysis completed by probation.
But this is also a case where the judge sentenced without a full understanding of previous convictions. Is that right? That without a full understanding that his offending behaviour, the record was worse than the judge understood at the time of sentence?
In part, although the details of that caution weren't provided on that occasion. So yes, there is that other matter the judge didn't have information about on the day. There wasn't, in fact, I believe, a plea at that date. But the details of the caution, the same is true. Attention has already been drawn to the point about a cliff edge in terms of age. I'm not sure I intend to go into it any further. He is 19 years old. What is assessed by probation is simply, in light of everything that had been happening in his life, the significant turmoil as a result of him returning, caring for his sister, that impacts his ability to make choices as a young man of 19. It's relevant to both his culpability and his risk. Unless I can assist any further.
A further point you make is that the judge was wrong to take culpability A rather than culpability B. Yes. Speaking purely for myself, I see how you set it out, and you've done some very useful research on a response from the Sentencing Council, I think the Justice's submissions. And again, speaking purely for myself, I'd welcome Mr. Atkinson's help as to whether he concedes that was an error by the judge. But you've made the point very fully.
And my lord, simply to refer to that point, it's the throwing of missiles in terms of targeting. It's considered in this matter, both in terms of lifting it to culpability A and in terms of being an aggravating factor in terms of his individual role.
Yes.
Thank you very much indeed.
Yeah, certainly.
Mr. Atkinson.
May it please, my lords. In terms of the respondent's submissions as to the general principles, the respondent submits that whilst context is not everything, it is extremely important to sentencing in cases such as this. Each of these offenders in their different ways were sentenced for participation in their different ways in widespread disorder in each of the locations where they were present. At each of those locations, that disorder involved significant numbers perpetrating sustained and significant violence towards persons and property. And that included in particular at each of those locations, which is relevant in the case of the appellants Williams, Tesan and Kush, violence directed towards the police who were seeking to protect those local communities. It is submitted on behalf of the respondent that that has to be the context in which each of these appellants falls to be sentenced, and also has to be the starting point to a consideration of how that sentencing should be approached. My lady, in the respondent's skeleton at paragraph 6, we draw attention to the purposes of sentencing, always a useful point to start in such an exercise.
Yes.
And the purposes of sentencing, as identified in section 57.2 of the Sentencing Act of 2020,
Yes.
identify that the purposes of sentencing include the punishment of offenders, the reduction of crime, including its reduction by deterrence, and the protection of the public. They are not the only purposes of sentencing, but they are apposite to cases such as this. There is triangulation, in effect, of the requirement to protect the public, to deter crime, and to punish those who engage and play a part in widespread disorder that undermines the safety of the community. That is not a novel submission from the respondent. That is a well-recognised approach, as this court has held on a number of occasions, at least since the 1970s, and I suspect before that. In our skeleton, my lady, we draw attention to the decision of this court in Caird at paragraph 10, of Fox and Hicks at paragraph 12, and in particular, the decision of this court, of my lady's predecessor, Lord Judge, at paragraph 13 in the case of Blackshaw.
I mean, since Blackshaw, of course, we've got the Sentencing Council guideline, haven't
Yes.
we? And certainly so far as public disorder is concerned in section 2, the Sentencing Council guideline takes account of the context
Yes.
of public disorder. So you would accept it's important not to double count.
Absolutely.
Yes.
But what, in my submission, the sentencing guideline in relation to violent disorder illustrates is the importance of looking at the incident in which someone participates and then considering their role within it. Because if one looks at the sentencing guideline and culpability B factors, which are the factors that are apposite in each of the cases where violent disorder was the offence in question, and I will turn to my Lord Justice Benathan's invitation to address culpability A in relation to that case in a moment or two. But the factors in identifying culpability in relation to violent disorder are that the offender participated in an incident which involved widespread and or large-scale acts of violence, that the offender participated in an incident involving serious acts of violence, and so on. It is clear that the culpability identified for the purposes of the violent disorder guideline is by reference to the incident rather than the individual. Now, that is not to say that the role of the individual is therefore irrelevant, as one of my learned friends sought to characterise the respondent's submission as being, because if one then considers the aggravating and mitigating factors in the violent disorder guideline, they are all about the individual in large part. And so the offending is aggravated where that particular person has played an active and persistent role, where they have incited others, where they have been masked, where they have used a weapon, where they have thrown missiles, and so on. And it is mitigated where they took steps to try to defuse the incident, or their level of involvement was a low one, or their role was a minor or peripheral one. And so we submit that the guideline reflects the approach in Blackshaw, and indeed those cases that preceded it, in considering the context, what the incident was, and what that incident involved, before then going on to considering whether the role that the particular person played aggravates or mitigates from the starting point that the incident itself warrants. And that, we submit, was reflected in each of these cases by the approach adopted by each of these sentencing judges. It is clear, and I'll turn to the individual cases in a moment, but it is clear that each of these judges was aware that they had to assess the incident and its impact, and then go on to consider the role played by the individual and the mitigation also available to those individuals before reaching a conclusion as to sentence. But we submit, my lady, that it follows from the proper approach to sentencing for widespread disorder such as this, that these are the kind of cases that the Sentencing Council had in mind in its guideline on the imposition of community uncustodial sentences, in recognising that there will be cases where it is not appropriate to suspend the sentence because only immediate custody can provide the appropriate punishment. It goes back to the approach in the Sentencing Act and the purposes of sentencing. It accords with the approach that this court has adopted in cases such as Blackshaw, and it also accords with the proper application of each of the guidelines that this court has to consider. And so, Mary Moores, those are our submissions as to principle. We've set out the relevant parts of those cases, and
Yes,
unless
you
it
have,
would
very
assist, I
helpfully.
won't go through those.
Thank you.
Turning then, if I may, to the individual cases, unless there's anything further I can say as to
Thank you.
principle. And taking the cases in the order in which the court has heard from the appellants, which I apologise, is not the order in which they're dealt with in my skeleton, but I will do my best to navigate the court through. So Mr. Kush is addressed in the skeleton at page 18.
Yes.
He, of course, is different from the other appellants because the offence to which he pleaded guilty is different. However, it is right in the Respondent's submission that the court sentencing Mr. Kush was nevertheless required to consider the context in which his offence had taken place. The guideline, and this is absolutely no criticism of the guideline. I would never dare criticise a guideline in this country.
Not in front of my Lord. Lord Holroyd, I think.
The guideline, as my Lord Mr. Justice Benathan has observed, deals with common assaults of a whole wide range and type. The guideline, therefore, addresses primarily community penalties as the outcome, whatever levels of harm or culpability are identified. But the offence that Mr. Kush pleaded guilty to was not just a common assault. It was a common assault relating to an emergency worker. And it is well recognised, and I cite by way purely of example the decision of this court in Welland at my paragraph 51, that an assault upon a police officer who is doing their duty is treated much more seriously by this court.
I mean, it doesn't... I'm keen not to be suggesting that anyone who commits that offence should get 4 times what the table says, but that's just as a bit of basic mathematics. That is the maximum sentence compared to the table.
Yes.
And it's a well-designed but conceivably counterintuitive approach to have a table for the offence which is a maximum of 6 months, and then say you aggravate it when the offence you're then moving to is 4 times as long. So it's a significant aggravating feature.
It is a recognition by Parliament through the imposition of that maximum sentence that offences of that kind are to be treated much more seriously. And it is recognised within the guideline that the fact that the person assaulted is performing the role of a police officer or other emergency worker is an aggravating feature. So the guideline is entirely consistent with that approach. But it does follow that in relation to the approach to Mr. Kush, the sentencing judge was required to take account of who it was that he had assaulted, and in my respectful submission, what that person was doing, where they were doing it, and what was happening at that time. That, we submit, is entirely consistent with the approach of this court in Blackshaw that recognised that the nature of the disorder that was ongoing was a relevant factor in relation to a range of offences, including offences of handling stolen goods and of theft and burglary, which were offences committed within the context of disorder that was addressed in Blackshaw. So the context, we submit, remains important. And it follows that whilst the conduct of Mr. Kush, viewed purely in isolation and ignoring who it was that he assaulted and where they were and what they were doing, might have resulted in a non-custodial penalty. None of that can apply in our respectful submission when that context and who it was that he was assaulting is brought back into the equation. In terms of the other complaint made on behalf of Mr. Kush in relation to his sentence, namely that insufficient weight was given to his mitigation and in particular to his mental health, and that the pre-sentence report, albeit a stand-down one, was not fully considered by the learned judge. Respondent submits that those submissions failed to take proper account of what the learned judge actually said when he was dealing with Mr. Kush in his sentencing, because it is clear from his sentencing remarks that he did take all that is now relied on behalf of Mr. Kush by way of mitigation into account.
What about the suggestion that it was wrong to cut off the recommendation?
Given the context, and given the seriousness of the offence in that context, the learned judge was entitled to conclude that this was an offence so serious that only a sentence of immediate custody was appropriate, because no other sentence was appropriate to punish this offence. And that being his conclusion, having heard from the author of the probation officer as to the mitigation available to Mr. Kush, he was not depriving himself, with the greatest respect, of anything that would have made any difference to his determination that a custodial sentence was necessary. Clearly, the probation officer would have been able to tell him whether or not Mr. Kush was capable of undertaking unpaid work, or whether there were courses available, and so on. But if the learned judge was of the view that custody was necessary, not knowing what courses were available or whether unpaid work was available would have made no difference. It is what the probation officer, with their experience, was able to bring to the learned judge's attention in terms of the mitigation and the circumstances that mattered to the learned judge's determination, and that was considered by him, as his sentencing remarks made clear. Unless, Lady Moores, I can insist further in relation to
Paul
Mr.
Williams.
Kush. So far as Mr. Williams is concerned, it is accepted that his offence fell within culpability B and harm 1. It is clear that he fell within culpability B because he ticked a good number of the boxes that would put him within that category under the sentencing guideline. But going back to the analysis that I took my Lady and the Lords through earlier, clearly the guideline is addressing the incident in determining the culpability, and then looking at the individual and factors relevant as aggravating or mitigating factors so far as they are concerned. And in Mr. Williams's case, there were a number of such aggravating factors. I should, my Lady, I'm so sorry, have said that I deal with Mr. Williams in my skeleton from page 7.
Don't worry, we've got that. Just on the facts, I couldn't see particularly clearly on the video how close the piece of metal that was thrown came to the police line. Can you help me on that, maybe?
I agree, my Lady, it's difficult to see. It was certainly aimed in their direction. It certainly got close enough to get a reaction from them as it came,
okay.
but I can't say more
Thank
than
you.
that. But, my Lady, dealing with the Mr. Williams, just separate from the incident to an extent, he clearly had in his case aggravating features relating to his previous record, but relating to the incident, it was no form, we submit, of doubly penalising him, to use my learned friend's words, to take account of the fact that he was clearly intoxicated, as he accepted at the time of his participation in this disorder, that his role was an active one, because the active or passive nature of the role is not addressed by culpability B. It is addressed by the aggravating features. And that he threw a number of missiles. Again, that is not addressed by culpability B. So far as he is concerned, it is addressed by the aggravating features. And to adopt a point made recently by my Lord Justice Holroyd, if, as is the case here, a number of the routes into culpability B are met, that can justify an increase from the starting point to reflect how many boxes you are ticking. Not that, of course, is how my Lord Justice Holroyd put it, but that, we submit, involves no double penalisation of Mr. Williams here. And so, turning to his second ground and to his mitigation, clearly by reference to the approach of this court in Petherick, the impact on Mr. Williams's family was a relevant factor for the learned judge to consider. It is clear from the approach in Petherick that it does not always mean that someone who would otherwise go to prison does not go to prison. It does mean, as the approach in Petherick makes clear, and in particular at paragraph 21 of Lord Justice Hughes's judgment, which I quote at paragraph 24 of my skeleton at page 10, that the impact on an offender's family has to be balanced against other factors that are relevant to the determination of sentence, including considerations such as deterrence and the protection of the public. It is clear, again, from the sentencing judge's remark that he had all that well in mind. And he did reduce the sentence that otherwise would have been imposed to take account of Mr. Williams's mitigation, including, as is clear, the impact on his family. But he was nevertheless required to take account by reference, not least to the context of whether the necessary punishment could only be achieved by immediate custody, and he was entitled to conclude that it was. That is, we submit, a proper application of each of the relevant guidelines in Mr. Williams's case. Unless I can assist further in relation to Mr. Williams,
Thank you.
turning to Mr.
William Willis, yes.
Willis, and this is page 14 of my skeleton.
Thank you.
My lady, Lords, I accept at the outset in relation to Mr. Willis that his age is an important factor that the court that was dealing with him and this court now need to take into account. The learned judge's approach, which in my respectful submission was the right one, was to consider by reference to the context and Mr. Willis's role the appropriate starting point and then the appropriate sentence for an adult, and then to consider the impact of Mr. Willis's mitigation, including, of course, his age, but also the issues in relation to ADHD and so on. Insofar as that approach was concerned to Mr. Willis, the learned judge, took account of the context. He took account of that which Mr. Willis did and recognised, as he was required to do, that he could not look just at Mr. Willis's determined attempts to break a window in isolation, but the context in which he was doing that, and that he had voluntarily participated in disorder that involved him playing that active part. It is right to say that having done that, he did only increase very little from the starting point to reflect the aggravating features that would otherwise have been present. For example, the use of the brick to break a window, that involves using it as a missile. It is a weapon in that sense. But he did not make any significant increase from the starting point, but he did then make a significant reduction from that point to reflect the mitigation. And so going from 39 months to 18 months to take 18-month reduction to take account of the mitigation available to Mr. Willis. He had been referred to and did take account of the sentencing guideline in relation to the sentencing of young people. He had been referred to and did take account of the sentencing guideline in relation to the sentencing of those with mental disorders.
Did he refer to that guideline in his sentencing remarks?
Lady, forgive me.
If we look at page 3, there's reference obviously to the guideline for violent disorder.
Yes. He had been,
yes,
as I understand, he had been referred to them, and he did refer to those.
Forgive me, if we look at Y8D, he does actually mention it in his preamble.
That's correct, thank you.
Doesn't he?
Yes.
Sorry, that's digital Y8D.
No,
Thank you,
But if we're on that page, Mr. Atkinson, this was an 18-year-old with a difficult start in life and all sorts of challenges.
Yes.
Who managed to get to 18 as being of good character, which is perhaps more of an achievement for him than for a lot of 18-year-olds. And when he's listing the mitigation that Mr. Wood has set out so persuasively, the judge doesn't mention his good character. And he mentions it in his preamble at some stage, but he doesn't list it as one of the reasons he's reducing the sentence.
Yes.
It's actually a pretty significant factor, isn't it?
It is. It is. And it sort of the three things almost work together. That there is the fact of his age, there is the fact of the challenges in relation to his mental health, and there is his good character. When those two things are taken together, and as a trio, they represent important mitigation. And an element of the trio was not identified again by the learned judge halfway down page 3, as I accept it should have been. But he did, nevertheless, reduce the sentence significantly to reflect the mitigation, and he had in his preamble taken account, amongst other things, of the good character. So it was not entirely ignored.
And one of the features here could be said is the link. I mean, one of the central points arising out of the mental disorder guideline and the considerations of youth is to what impact that has on culpability.
Yes.
And there really there's a very clear link here.
Yes.
Between immaturity and autism and ADHD.
Yes.
And the thinking process here. Is that fair?
Yes, and so the learned judge was required, effectively by the guideline, to take that into account. If there was no link between the mental disorder,
it would be a separate, discrete point with far less potency.
Yes, but that is not the situation in relation to Mr. Willis, and so the respondent accepts that there was important mitigation in the case of Mr. Willis that the learned judge was required to take into account. He did reduce the sentence by 18 months from where he had reached for that purpose before giving credit for the plea, and it really is an assessment for this court as to whether that degree of reduction was enough or not.
Understood.
Unless I can further in
thank you very
relation to Mr. Willis, can I turn to Mr. Temesgen?
It's fair to say that this was an unlawful sentence.
The learned judge did not actually use one word or the other.
Except in the course of his sentencing remarks, Mr. Atkinson, I think he refers to prison twice.
He does.
So,
and
that's
so
very fair.
the court should, for safety at least, proceed on that basis and can correct that. And this is page 11 of my skeleton.
Thank you.
Can I deal first in relation to Mr. Temesgen with that point which I know my Lord Mr. Justice Benathan would like me to deal with, which is the question of whether this was culpability A or B.
Well, Lord Justice Holroyd is the real expert on this, but your paragraph 31 is not exactly an enthusiastic defence of the judge's stance. Is that fair?
I could be more enthusiastic in other places. I think it is an interpretation of what the sentencing guideline says, to say that targeting of individual with an S after it does allow for targeting of a group to represent a route into culpability A. It is not perhaps the most obvious interpretation.
It risks putting almost every offence into category A, doesn't it? The nature of violent disorder. Somebody is using or threatening violence against somebody else.
And I recognise, my Lord, that if a targeting of a group is a correct interpretation of it, then each of these offenders who was involved in violent disorder could have fallen into culpability A on the same basis. Other judges did not take that route.
You have the rather curious feature of the lone crusader taking on the hordes of the opposing group being treated as high culpability because he targeted them. It seems counterintuitive.
No one else is throwing anything when he throws the bottle. I mean, from the counter-protesters, they're all behaving, as far as I can see, perfectly lawfully.
Yes.
They're shouting and stuff, but
Yes.
they're allowed to do that.
That's sort of what happens, yes. And so whilst the respondent submits there is a route that would have allowed the learned judge to adopt the approach he did, that the safer course may be to consider whether, had the learned judge started at culpability B, actually the sentence at which he reached at the end would have been different. And in the respondent's respectful submission, it would not have been, because the culpability B would have addressed the incident in which Mr. Temesgen was involved, and then his role within it would have resulted in an increase from the starting point to reflect the aggravating features which I identify at my paragraph 32. He was an active participant. He was persistent because there were warnings from the police for him to desist, and he didn't. He threw a number of missiles, and he had a mask on when he did so. And so, before...
Two missiles?
Yes.
Yes.
Before then considering the reduction to reflect his, to use the learned judge's description, enormous mitigation, the approach would have resulted in effectively the same level of sentence, even if the learned judge had not adopted the linguistic approach that he did to culpability A. So far as the mitigation is concerned, as with Mr. Willis, the mitigating features available to Mr. Temesgen are significant. They interact with each other, as my Lord Mr. Justice Benathan observed that they did in relation to Mr. Willis. And the court was required to give significant reduction to reflect them. The respondent submits that it did, but it also had to assess whether, by reference to the guideline for the imposition of custodial or community penalties, this was nevertheless a case where necessary punishment could only be achieved by immediate imprisonment or detention, and that was the assessment available to the learned judge and which he took. Milady, can I just, in passing, submit that factors such as, if it was 12 months and not more, that would have had different results thereafter, rather as this court found in the case of Patel in relation to the changing of minimum terms, and that being a question for Parliament, not a question for sentencing judges. Those type of factors, I respectfully submit, are not factors that the learned judge was required to take into account in determining the proper level of sentence, nor should this court do so now. The question for this court, in my respectful submission, is whether the learned judge gave sufficient weight to Mr. Temesgen's mitigation. It is clear he identified all the relevant factors, and that therefore is assessment for the court. As
well,
to
there is
was...
a bit more to it, isn't there? Because it is said that without a PSR, without a pre-sentence report, the judge did not have the full picture as revealed in the pre-appeal report, particularly relating to his state of mind at the time of the offending, etc., etc. What do you say to that?
In my submission, Lady, clearly it was recognised by this court in Meanly that particularly in relation to young offenders, that pre-sentence reports should be obtained because they are of significant assistance to those charged with sentencing. It is, however, less clear, taking this case as an individual one, whether in fact the learned judge would have been significantly assisted by such a report to the extent that it would have altered his assessment by reference to all the other relevant factors as to whether necessary punishment in this case could only be achieved by an immediate custodial term, because that clearly is the thing that a pre-sentence report could have made a difference to. But it rather, as with Mr. Kush, although the learned judge here didn't have the recommendations of the probation service in the same way that the learned judge in the case of Mr. Kush didn't, he did have the relevant factors that would have formed part of such a pre-sentence report, because he clearly identified and had identified to him the mitigation available to Mr. Temesgen. And again, therefore, respondent submits that failure to obtain a report, which is perhaps regrettable, does not alter the assessment as to whether Mr. Temesgen's sentence was manifestly excessive or not.
No, thank you very much.
No. Thank you very much, Mr. Atkinson, for your clear oral and very clear written submissions as well. We are very grateful to all counsel for their endeavours. Anything that anybody would like to respond to or add? No. Obviously, we are going to have to consider carefully the full submissions that we have received. We hope to be in a position to give judgment at 2 o'clock this afternoon. The applicants are, of course, able to attend, but they are not required to be here. I hope you have the opportunity to make some sort of contact with your clients at this stage, and they can hear what I'm saying now in any event. We will try to communicate to you if we anticipate there being any significant delay to that proposed timetable, but at the moment we would ask everybody to come back into court, please, for 2 o'clock. Thank you. Mr. Granville and Mr. Atkinson, I will be delivering the court's judgment on generic issues. My Lord Justice Holroyd, Vice President, and my Lord Mr. Justice Benathan will be dealing with the individual cases.
Thank you.
Introduction. In late July and August 2024, a series of violent disturbances erupted across England following a tragic incident on the 29th of July 2024 when 3 young girls were fatally stabbed at a dance class in Southport. The violence, fuelled by misinformation and far-right sentiment, spread to various towns and cities across the nation. Mosques and hotels housing asylum seekers were targeted. Significant damage was caused and injuries sustained. Those subjected to violence or threats of violence included police officers whose duty it was to protect the communities under attack. Many of those responsible for the violence in England were quickly identified, arrested and brought before the courts, where they were swiftly convicted and sentenced. We have before us applications for leave to appeal against sentences imposed on 4 individuals, each convicted following a guilty plea for his participation in incidents of serious public disorder. 1. Whitehall on the 31st of July 2024. Ozzy Kush, then aged 20, pleaded guilty at his first appearance before the Reading Magistrates Court on the 8th of August 2024 to a single offence of assault by beating of an emergency worker, contrary to Section 1 of the Assaults on Emergency Workers Offences Act 2018. He was sentenced on the 9th of August 2024 by His Honour Judge Kelleher, sitting in the Crown Court at Inner London, to 46 weeks detention in a young offender institution. 2. Sunderland on the 2nd of August 2024. Paul Williams, then aged 45 years, pleaded guilty at his first appearance before the South Shields Magistrates Court on the 9th of August 2024 to a single offence of violent disorder contrary to Section 2, subsection 1 of the Public Order Act 1986. He was sentenced on the 16th of August 2024 by His Honour Judge Paul Sloane, King's Counsel, sitting in the Crown Court at Newcastle upon Tyne, the Recorder of Newcastle, to 26 months' imprisonment. 3. Middlesbrough, on the 4th of August 2024. Dylan Willis, then aged 18 years, pleaded guilty at his first appearance before the Teesside Magistrates Court on the 20th of August 2024 to a single offence of violent disorder contrary to Section 2, subsection 1 of the Public Order Act 1986. He was sentenced on the 2nd of September 2024 by His Honour Judge Francis Laird, King's Counsel, sitting in the Crown Court at Teesside, to 14 months' detention in a young offender institution. 4. Plymouth, on the 5th of August 2024. Aminadab Temesgen, then aged 19 years, pleaded guilty at his first appearance before the Plymouth Magistrates Court on the 28th of August 2024 to a single offence of violent disorder contrary to Section 2(1) of the Public Disorder Act 1986. He was sentenced on the 30th of August 2024 by His Honour Judge Robert Linford, sitting in the Crown Court at Plymouth, to 14 months' imprisonment. We note at once that the imposition of a sentence of imprisonment on a person aged under 21 years is prohibited by Section 227 of the Sentencing Act 2020, the Sentencing Code. The sentence should have been one of detention in a young offender institution. The role of the courts and relevant sentencing principles. We begin by referring to two provisions of the Sentencing Code. Section 57, relating to the purposes of sentencing adults, and Section 59, relating to sentencing guidelines and the duty of the court. Subject to certain exceptions which are not material to these applications, Section 57, subsection 2, provides that when sentencing an adult aged 18 or over at the time of conviction, the court, quote, must have regard to the following purposes of sentencing: A, the punishment of offenders; B, the reduction of crime, including its reduction by deterrence; C, the reform and rehabilitation of offenders; D, the protection of the public; E, the making of reparation by offenders to persons affected by their offences, end quote. It can be seen from the chronologies outlined above that the individual cases before us came on for sentencing in the Crown Courts within days of conviction in the Magistrates' Courts. This judicial expedition was in line with the court's duty to have regard to the reduction of crime by deterrence and the protection of the public. By Section 59, quote, every court, A, must, in sentencing an offender, follow any sentencing guidelines which are relevant to the offender's case, and B, must, in exercising any other function relating to the sentencing of offenders, follow any sentencing guidelines which are relevant to the exercise of the function, unless the court is satisfied that it would be contrary to the interests of justice to do so, end quote. In each of the cases before the court, the offence concerned is the subject of a specific definitive guideline published by the Sentencing Council. Also relevant in some of the cases is the Imposition of Community and Custodial Sentences Guideline, the Imposition Guideline. In the context of widespread and significant public disorder, it is not only the precise individual acts of an offender that matter. It is the fact that the offender is taking part in violent disorder, threatening violence against other people and or property, and is part and parcel of widespread threatening and alarming activity. This is the gravamen of the offending, being one of those who, by weight of numbers, pursues a common and unlawful purpose. Thus, whilst what an individual offender may have done themselves is of relevance, their acts must not be taken in isolation. Rather, the court must look at the whole picture. This principle is well established by cases such as Crown against Caird and others, 1970, 54 Criminal Appeal Reports 499 at 506 to 508, Crown against Fox and Hicks, 2005, EWCA Crim 1122, 2006, 1 Criminal Appeal Reports Sentencing 17 at paragraph 16, and Crown against Blackshaw and others, 2011, EWCA Crim 2312, 2012, 1 Criminal Appeal Report Sentencing 114 at paragraph 8. In Fox and Hicks, the court at paragraph 16 encapsulated the principle in these terms, quote, "In the case of public disorder, it is important for the court to look at the whole picture, and although what an individual may have done by himself is of relevance, that is simply part of the whole to which he is contributing in his way, and the larger picture must be taken account of," end quote. In Blackshaw, this court considered appeals against sentences imposed for offences committed in the summer of 2011 in a series of riots and incidents of serious disorder which began in London and spread to other parts of the country. The sentences under consideration there had been imposed not for offences contrary to the Public Order Act 1986, but rather for offences of burglary and theft committed during this disorder by persons looting shops. The court made clear that the context of the offending made the individual offences more serious than they would be if they stood in isolation, and justified sentences in excess of those which would be appropriate for offences of burglary and theft committed in different circumstances. The weight to be given in the sentencing process to the need for deterrence may similarly vary according to the context of the offending. If public safety is under threat because of the potential spread of violence across the nation, then deterrence may be of the highest importance. The cases now before the court illustrate the speed with which disorder in one part of the country may be replicated in other areas, each incident encouraging and promoting further incidents elsewhere. Defendants who choose to involve themselves in activity which threatens the safety and well-being of communities across the nation must therefore expect severe sentences designed not only to punish them, but also to deter others. As it was put by Lord Judge Chief Justice in Blackshaw, quote, 4. There is an overwhelming obligation on sentencing courts to do what they can to ensure the protection of the public, whether in their homes or in their businesses or in the street, and to protect the homes and businesses and the streets in which they live and work. This is an imperative, ... The imposition of severe sentences intended to provide both punishment and deterrence must follow. It is very simple. Those who deliberately participate in disturbances of this magnitude, causing injury and damage and fear to even the most stout-hearted of citizens, and who individually commit further crimes during the course of the riots, are committing aggravated crimes. They must be punished accordingly, and the sentences should be designed to deter others from similar criminal activity." End quote. It should be noted that the offence of violent disorder, contrary to Section 2 of the Public Order Act 1986, requires the use or threat of unlawful violence by 3 or more persons present together, and may be committed in private as well as in public places. It can, of course, be committed, as it was in each of these cases, by a very much larger number of persons present together. The statutory maximum penalty of 5 years' imprisonment therefore applies to a wide range of offending. That feature of the offence and the principles to which we have referred were taken into account by the Sentencing Council in developing the Violent Disorder Guideline and the guidelines relating to other offences involving public disorder, all of which came into effect on the 1st of January 2020. The public consultation, which preceded the definitive guideline, noted that the offence of violent disorder can involve a broad range of activity, including offences akin to riot, where all of the elements of the yet more serious offence of riot may not be made out. With that in mind, the offence range stated in the guideline goes up to 4.5 years custody. The culpability and harm factors to be considered at step 1 of the sentencing process require consideration of, amongst other things, the scale and seriousness of the incident of disorder and the nature and extent of the harm caused or threatened. The focus at step 1, when considering culpability category B, is on the nature of the incident itself. When applying an offence-specific sentencing guideline, a sentencer is required by Section 60, subsection 4 of the Sentencing Code to decide which of the categories most resembles the offender's case in order to identify the sentence starting point. The sentencer may then make an initial adjustment of that starting point, upwards or downwards, to reflect particular features of culpability and/or harm, such as the presence of a multiplicity of features of the relevant category, or the presence of a feature indicative of a lower category, or an assessment that the particular offence comes high or low in the range covered by the relevant category. In cases such as those now before the court, a particular offence may properly be regarded as coming high in the range where one or more of the guideline factors is present to an unusually large or serious extent. For example, where the offender has participated in an incident which involves very widespread and/or particularly large-scale acts of violence, and/or which contributes to a wider picture of incidents of disorder in different parts of the country. It may also come high in the range where the overall picture which the court must take into account makes it particularly important for the sentence not only to achieve appropriate punishment for the individual offender, but also to deter others from engaging in similar disorder. At step 2 of the sentencing process, when the sentencer is considering aggravating and mitigating factors, the guideline includes a specific caution against double counting of, quote, aggravating factors which were relevant to the culpability assessment, particularly in cases where culpability is assessed as high, end quote. Such caution is always necessary when applying a sentencing guideline, because the guideline offence range and sentence starting points will reflect the inherent seriousness of the offence. However, the aggravating and mitigating factors at step 2 include several which focus on the precise role played by the individual offender, and identification of such factors as aggravation will not necessarily involve double counting. The guideline applicable to offences of common assault on an emergency worker, for which the maximum penalty is 2 years custody, requires the sentencer to determine the appropriate sentence for the basic offence of common assault and battery, which has a maximum sentence of 6 months custody, and then to apply an uplift in accordance with the guidance given at step 3 of the process. The guideline specifically states that the uplifted sentence, quote, may considerably exceed the basic offence category range, end quote. The guideline states that the sentencer should state in open court that the offence was aggravated by reason of the victim being an emergency worker, and should also state what the sentence would have been without that element of aggravation. The non-exhaustive list of aggravating factors applicable to the basic offence does not include express reference to the offence being committed in the context of public disorder, but in the light of the principles we have stated, that context can undoubtedly be regarded as a serious aggravating factor. Some of the submissions made to the court suggest that there is an issue as, quote, whether the application of deterrent sentences inherently prevents consideration of suspended sentences, end quote, fresh quote, prevents exceptions due to the offender's specific role or to the mitigation available, end quote, and, quote, curtails the need for a pre-sentence report, end quote. We do not consider that any such generic issue arises, because issues such as whether a pre-sentence report is required or whether a custodial sentence of 2 years or less can and should be suspended will require fact-specific decisions in each case. For the avoidance of doubt, however, we make clear that sentencers must follow any relevant guideline and consider all features of the case in order to determine what sentence is just and proportionate in all the circumstances. The need for a sentencer to give due weight to deterrence does not of itself preclude consideration of whether, in accordance with the imposition guideline, a custodial sentence of appropriate length can be suspended. Where the offending involves serious public disorder, however, the application of that guideline may well lead to the conclusion that appropriate punishment can only be achieved by immediate custody. Against the above background, we turn now to the merits of each of the individual cases.
The individual cases, Aussie Kush. On 31st July 2024, there was a protest held in Whitehall. In the event, no widespread disturbance ensued, but at the time of the applicant's offence, people were shouting aggressively at police officers and refusing to comply with a dispersal order. The court has watched body-worn footage from one of the police officers involved. The air of menace and the potential for violence is tangible. Police Constable Munt was filming the protesters when the applicant kicked out at him, striking his hand. It was, on the evidence we have seen, a hard kick, but fortunately no lasting injury was caused. PC Munt wrote of shaking his hand to get the feeling back into it, as it was smarting from the blow. In passing sentence, the judge was to comment that, quote, your action also ran the risk of inflaming the wider situation and encouraging others to attack the police, end quote. That comment was both justified and significant. The applicant pleaded guilty at the first opportunity and was committed for sentence. He was 20 years old. At the time of the offence, he was awaiting sentence after pleading guilty to 2 offences of criminal damage. One was committed some 6 weeks before the instant offence, the other committed 2 days after, when, on being released from Croydon Police Station, he smashed a glass pane. The judge had the advantage of a pre-sentence report which wrote of the applicant reporting traumatic events in his childhood and suggested that this may have led to some memory lapses and emotional instability. The same report offered the possibility of a community order with conditions of unpaid work and a number of rehabilitation activity requirement days. For the applicant, it is submitted that the judge was wrong to characterise the harm as Category 2 rather than Category 3, and that the sentence imposed was manifestly excessive. The grounds of appeal point out that the eventual sentence was in the order of 4 times the upper end of the range, even for the A2 categorisation at which the judge arrived. It is also submitted that the judge interrupted the probation officer during his oral report to the court, with the result that the officer's recommendation was not taken into account. The judge explained his approach in commendably concise and well-structured sentencing remarks. He accurately summarised the applicant's conduct as follows, quote, "Your action in kicking the officer was clearly deliberate. It displayed a complete contempt for the police on your part. You clearly intended to make contact with the officer and cause him physical harm. Your action also ran the risk of inflaming the wider situation and encouraging others to attack the police, although fortunately, at that time at least, that did not happen." End of quote. The offence involved high culpability because the applicant used his shod foot as a weapon equivalent. Although it was submitted that the harm caused was in Category 3, quote, "no/very low level of physical harm and/or distress," end quote, the judge held that it fell within Category 2, quote, "minor physical or psychological harm/distress," end quote. In the light of the officer's description of the immediate pain which he experienced and his needing to shake his hand in order to regain feeling in it, the judge was entitled so to hold. A basic offence in Category 2A attracts a starting point of a medium-level community order, with a category range from a low-level community order to 16 weeks custody. Whilst the judge did not identify what sentence he would have passed without the element of aggravation arising by reason of the victim being an emergency worker, he did rightly observe that the guideline starting point, quote, ... applies to all common assault offences. Where the offence is committed against a police officer, that is an aggravating factor which may justify a sentence considerably exceeding the range for the basic offence. In this case, the significance of that aggravating factor is magnified for the reasons I have already explained. The officer was not just carrying out his duty, but was doing so in particularly challenging and volatile circumstances." End quote. This case provides, in our view, a clear illustration of the need to consider the seriousness of offending such as this by reference not only to the applicant's specific conduct, but also to the wider context. The applicant was on bail for a recent offence of criminal damage. He must have known from the loud and clear police announcements that the police had issued a dispersal order. The applicant began to walk away from the police, but instead of continuing to do so, he went back deliberately to attack the officer who was filming events. That action clearly risked provoking similar violence from others in circumstances where the police were having to respond to a challenging situation. A very substantial uplift from the sentence which would have been appropriate for the basic offence was clearly necessary. The judge took into account the mitigation available to the applicant, including his youth, poor mental health, and possibly personality disorder, but was entitled to give much of it limited weight, given the deliberate nature of the offending. We can see no basis on which it could be argued that the sentence of 16 months or 69 weeks custody before the appropriate reduction for the guilty plea was manifestly excessive. The judge reflected on whether the sentence could be suspended. He expressly considered but rejected factors identified in the imposition guideline as favouring suspension. He concluded that those factors were, in any event, clearly outweighed by the circumstances of the case, and that appropriate punishment could only be achieved by immediate custody. The judge was plainly entitled to reach that conclusion. We are not persuaded that he failed properly to consider all possible alternative outcomes. Having heard all of the background, it was preeminently for his judgment whether to hear more from the probation officer than he did. For those reasons, the application for leave to appeal against sentence is refused. Paul Williams. On 2nd August, there were riots in Sunderland. There was very widespread destruction. Police officers were injured and there was extensive damage to property. In the middle of that disturbance, the applicant shouted at the police line, assumed a boxer's stance, and urged the officers to come and fight with him. He took his top off, and the volume of noise from the crowd, already loud and intimidating, rose appreciably. The applicant was persistent, loud, and abusive. He threw a drink at the police that struck a shield. Then later he threw a piece of metal which fell just short of police lines. The CCTV of the event shows the applicant as being very loud and very aggressive. He was later identified from CCTV and arrested. He pleaded guilty in the magistrates' court. The judge had the assistance of a witness statement from the Chief Constable of Northumbria Police, setting out the extent of the damage and injuries caused. The applicant was 45. He was clearly drunk during these events. He has a number of previous convictions which, while not the most serious, stretch from 1997 to 2021 and include cautions or sentences for violence, obstructing police, harassment and breach of court orders. He had never previously served a custodial sentence. A pre-sentence report described a difficult childhood and some mental health difficulties, namely anxiety, depression and panic attacks. He played a role in caring for his unwell mother. Before his arrest, the applicant had care of his 14-year-old son, who lived with him, and regular contact with his daughter, who lived with his former partner but would regularly stay with the applicant. By the time of sentence, the son was also back living with his mother, the applicant having been remanded in custody. The pre-sentence report wrote of the applicant's genuine remorse at his conduct. The judge was provided with a report from the Children and Family Court Advisory and Support Service, which concluded that the applicant and his former partner were cooperating well and the children were happy with their accommodation and contact arrangements. For the applicant, it is submitted that the sentence should have been limited to 2 years and then suspended. It is said that there was double counting in respect of the applicant's involvement as an active and persistent participant. The judge described the applicant and others as having participated in an orgy of destruction, violence and disorder, which moved from area to area, was sustained and persistent, and involved serious acts of violence towards persons and property. He referred to the statement of the Chief Constable and described the impact of the offending on her officers and on the community. In a succinct and correct statement of principle, the judge said, quote, ... it is an unavoidable feature of mass disorder that each individual act, whatever might be its character taken on its own, inflames and encourages others to behave in similar fashion. That is why the court will have regard to the overall picture. Those participating in mass disorder must expect severe sentences, intended not only to punish, but also to deter others from copying their example." End of quote. The judge rightly held that this case fell within category B1 of the guideline, which carries a starting point of 3 years custody with a range of 2 to 4 years custody. It is important to note that culpability was in category B because 3 of the 4 factors listed in that category were present. Harm was in category 1 because multiple category 2 factors were present. In fact, all 6 of the factors listed in category 2. The multiplicity of culpability factors justified a significant initial adjustment upwards from the category starting point. Some further upwards adjustment was justified because all category 2 harm factors were present, and the case was therefore even more serious than a case with multiple such factors. It is accepted rightly for the applicant that the offence was aggravated by the applicant's intoxication. We are not persuaded that the judge fell into the error of double counting in relation to the other 2 aggravating factors which he identified. The nature of the overall incident in which the applicant was involved was reflected in the category B culpability factors. But all those factors would have been present even if the applicant had not himself been as active and persistent a participant as he was, or if he had not himself thrown missiles at the police. The judge was entitled to take into account those features of the applicant's personal role in the overall disorder, consistent with the list of aggravating factors set out at step 2 of the guideline. In those circumstances, a sentence at or near the top of the category range was appropriate before consideration of the applicant's personal mitigation. There were undoubtedly valid points to be made on his behalf, as the judge rightly accepted, including in particular the applicant's care responsibilities towards his mother and the negative effects which the applicant's imprisonment would have on his 2 children. The children's rights had to be considered, and it was, of course, no fault of theirs that their father had chosen to behave as he did. It is, however, clear that the judge carefully considered that aspect of the case. He took into account, rightly, that the children were and would remain in the care of their mother. We have the benefit of a pre-appeal report which confirms that the applicant's son and daughter remain with the mother and that his son's upset would be managed by the family. In our view, the judge properly reflected all the mitigating features in deciding that the appropriate sentence before credit for the guilty plea was 3 years, 3 months imprisonment. It follows that the final sentence was of a length which could not be suspended. Thank you.
Dylan Willis. On the 4th of August, there was a protest in Middlesbrough that turned violent. That disorder was on a large scale. Chief Constable made a witness statement setting out its extent. Police were assaulted, an extensive range of properties were damaged, shopkeepers and other members of the public reported feeling scared. In what appears to be the early stages of these events, the CCTV shows the applicant throwing a brick against the window of a Chinese takeaway several times until the window broke. The applicant handed himself in to the police when he saw published images and realised he was wanted. The applicant was 18 and of previous good character. His mother had been unable to cope with him living with her, so at the time of the offence he was homeless, or at least sleeping at the homes of any friend who could accommodate him. A pre-sentence report listed his many problems. He'd been in care, diagnosed with ADHD, and there were other mental health concerns about self-harm in the past. The report recommended an unpaid work order with some courses and activities. The applicant's grounds of appeal argue that his sentence was manifestly excessive, essentially on the basis the judge did not make sufficient allowance for his mitigation, both as to his limited role and his personal mitigation. In passing sentence, the judge took category B1 in the Sentencing Council guidelines, which, as already mentioned, carries a starting point of 3 years custody with a range of 2 to 4 years custody. The judge went above 3 years to 3 years and 3 months to allow for the widespread disorder of which the applicant's offending was a part. He then made a reduction of 18 months to reflect the applicant's age and lack of maturity, his developmental challenges and low IQ, that he was a vulnerable care leaver, and that he handed himself in to the police. The consequent 21 months was then reduced by a third for his early plea, leading to a final sentence of 14 months detention in a young offender institution. The judge was faced with a difficult sentencing exercise dealing with this young, complex offender as similar disturbances racked the country. His choice of category under the guideline was unarguably correct, and his addition of some months for the aggravation of the broader context of the appellant's offending was, if anything, moderate. To state, as we have done, that an offender's sentence has to reflect both his actions and the overall disturbance is not to say that the nature and extent of the individual actions are immaterial. Indeed, as set out above, Step 2 under the guidelines requires them to be considered. Here there was a brief attack aimed at property, not people, albeit it involved the use of a brick. In terms of mitigation, it was significant that the applicant handed himself in to police in terms of remorse and acceptance of responsibility. His youth and background were also important. The courts have long observed that an offender's 18th birthday is not a, quote, cliff edge, unquote, and in dealing with an 18-year-old who is immature and has a low IQ, a court may need to approach sentence as if dealing with one who, in law, is a child. In addition, the applicant was of previous good character after a childhood which had exposed him to trauma and abuse, and following which he was left as a vulnerable young person supported by the local authority as a care leaver. In the probation officer's assessment, the appellant's ADHD and autistic spectrum condition significantly impacted his thinking and conduct. The judge was rightly directed to the Sentencing Council guideline for offenders with mental disorders. For offenders with mental disorders, developmental disorders or neurological impairments. The appellant would easily be drawn by others, and his lack of maturity played a role in his offending behaviour. The applicant's various intellectual and developmental problems also meant he was vulnerable to unhelpful influences in custody. Counsel has not argued against the judge's conclusion that a custodial sentence was unavoidable and necessary to mark the seriousness of the offence. We are not persuaded there is any basis for criticising the length of the custodial term which the judge reached by the route we have identified. The central issue in this appeal is whether this court should interfere with the judge's conclusion that appropriate punishment could only be achieved by an immediate custodial sentence. We have found this a difficult decision. We are persuaded that the exceptional and exceptionally powerful combination of mitigating features, and in particular those personal to this young applicant, should have led the judge to conclude that appropriate punishment could be achieved by a suspended sentence. Accordingly, whilst we have hesitated to differ from the conclusion reached by the judge, we have concluded that this court should interfere with the decision below. We therefore grant leave to appeal. Having regard to the suggestion made in the reports before the court, we quash the sentence of 14 months immediate detention and substitute a sentence of 14 months detention in a young offender institution suspended for 2 years with a rehabilitation activity requirement for up to 40 days. Amindag Temesgen. On the 5th of August, there was a disturbance in Plymouth. The judge described it as people descending on the city who, quote, ran amok, threw stones, fireworks and missiles, intent on damaging property and harming others. It was widespread lawless behaviour, with people both using and threatening unlawful violence, end of quotation. On the CCTV of these events, the applicant first appears in the main right-wing demonstration where, he said, he was racially abused. He was pushed to the other side of police lines where there were a number of counter-demonstrators. Shortly thereafter, he covered his face with a surgical mask, then threw an object over the police lines towards the other protest. It was probably a drink because it spilled liquid. He ducked away, then threw another object, probably a bottle. When later arrested, he confessed and apologised. The applicant was 19. He had been hoping to pursue a career in the law. He pleaded guilty at the first opportunity and had character references from his church and community describing him as a good, well-behaved young man. At the hearing, it was said he had no previous convictions, but a caution for battery in April 2024. A post-sentence report also mentions a dangerous driving offence to which he had entered a guilty plea earlier in the year. For the applicant, it is submitted the judge chose too high a category of culpability, category A, erred in failing to obtain a pre-sentence report, and was wrong not to have suspended the sentence. In his sentencing remarks, the judge considered the violent disorder guideline, as the applicant accepts harm was in category 1 because of the presence of multiple category 2 factors. The judge held that culpability was in category A because factors in category B were present and there was, quote, targeting of individuals by a group, unquote. Category A1 has a starting point of 4 years custody and a range from 3 to 4 years, 6 months. We grant leave. With great respect to the judge, we accept the submission that he fell into error in categorising the case as he did. The category A culpability factor relates to the targeting by a group of an individual or individuals who are fewer in number than the group. It is therefore not a factor which applies where, as here, one group is using or threatening violence against another group. A judge should, therefore, have placed the case into category B1, with a starting point of 3 years custody and a range from 2 to 4 years custody. Further, we agree that in a case such as this, it would have been preferable for the judge to obtain a pre-sentence report, as Mr. Atkinson, King's Counsel for the Respondent, very fairly conceded. Here, after all, was a young defendant with family commitments facing custody for the first time. Was the sentence wrong in principle or manifestly excessive as a result? We have no doubt that it was not. We accept the respondent's submission that the number of category B culpability factors justified an initial upwards adjustment of the starting point. The judge was then correct to identify 3 aggravating features of the applicant's individual actions, of the appellant's individual actions within the overall disorder. He was an active and persistent participant, undeterred by being pushed back and struck by a police officer in the early stages of his involvement. He thereafter put on a mask, plainly because he did not want to be readily identifiable as he pursued his intended actions. And he threw 2 missiles. Before a consideration of mitigation, therefore, a sentence in the upper part of the B1 category range was appropriate. The mitigation was substantial. The judge no doubt felt able to proceed without a pre-sentence report because he was going to sentence, as he made clear, on the basis that he accepted, for example, the appellant's immaturity, previous good prospects, and heavy family responsibilities. We have the benefit of a prison report and a pre-appeal report, which we have taken into account in reaching our conclusion today. The pre-appeal report suggests that the familial burden impacted on his, quote, emotional management and decision-making, unquote. This adds little to the picture that was already before the judge. The eventual sentence of 21 months before credit for the guilty plea did not fail to accord sufficient weight to the overall mitigation. The judge considered whether the sentence should be suspended. He accepted that most of the factors listed in the imposition guideline as favouring suspension were present. He was entitled, nonetheless, to conclude that appropriate punishment could only be achieved by immediate custody. The judge did not express that conclusion in the precise terms used in the imposition guideline, but we do not accept the submission that the judge's use of the phrase, quote, "this is far too serious for anything other than immediate custody," unquote, indicates an error of principle or of approach. It is clear the judge had the imposition guideline in mind and he applied it correctly. For those reasons, there is no good ground on which to challenge the imposition of an immediate sentence of 14 months custody. The sentence was expressed as one of imprisonment, a sentence which was not available because of the appellant's age. The sentence was therefore unlawful and must be corrected, though the correction will make no difference to the length of the sentence. We accordingly allow the appeal to the extent we quash the sentence of 14 months imprisonment and substitute a sentence of 14 months detention in a young offender institution.
Thank you, John. Conclusion. For these reasons, we refuse leave to appeal against sentence in the cases of Kush and Williams. We grant leave to appeal against sentence in the cases of Willis and Tesan. We allow the appeal in the case of Tesan for the limited purpose of correcting the unlawfulness of the sentence of imprisonment passed on him. We quash that sentence and substitute it with a sentence of 14 months detention in a young offender institution. All other aspects of his sentence remain in place as before. We allow the appeal against sentence in the case of Willis. We quash his sentence of 14 months detention in a young offender institution and substitute it with a sentence of 14 months detention in a young offender institution suspended for 2 years with a requirement of up to 40 days rehabilitation activity. That concludes our judgments. We repeat our thanks to all counsel. Mr. Wood, I need to speak with Mr. Willis now to ensure that he understands the impact and effect of a suspended sentence. Mr. Willis, can you please raise your hand? Can you hear me? If you breach the terms of your suspension, that is the requirement to complete rehabilitation activity requirement, or that you commit any further offence, you are liable to be recalled to detention immediately. Your sentence may be reactivated and potentially increased. Do you understand that? Mr. Wood, your counsel, can also explain it to you, but is that clear to you at the... Mr. Wood, are you happy? And you will also have the opportunity to explain the full impact and meaning of the suspension. Are there any other matters that we can usefully address at this stage?
No, thank you.
I know that there are a large number of members of the press, both in court and also viewing, I think. I hope that there will be some written material available as soon as possible to help you in your consideration of today's judgment. Thank you all very much indeed.